Good afternoon, everyone. I'm Joanne Bone, and I'm a partner in the commercial team, and I lead our data protection practice. I'm delighted this afternoon to be joined by Hannah, who's an associate in the team. So welcome to the webinar. When you got invited, you will have seen that it was called the Data Use and Access Bill webinar, looking at the UK data protection reform. Well, it's now the UK, essentially it's the Act, it's the Data Use and Access Act. So it's perfect timing because yesterday, following some ping-pong between the House of Commons and the House of Lords, the bill was passed. So we'll have a look at where we got to and what it says today. A couple of housekeeping points. The first one is, if you've got any questions, please will you put them in the Q&A and not in the chat. And the other point is that there will be a feedback form that will be released throughout the webinar. And if you could fill in the feedback form, that would be great. It'll be, I think, with about 5 minutes in and then various different points and at the end. It will also be recorded. So you will get the slides and the recording later. So don't worry about that. So perfect timing then, I think. If we can move to the next slide, what happened? So this is the third attempt at data protection reform. So those of you who watch data protection issues will know that during the Conservative governments, there was DPDI 1 and DPDI 2. And then with the change of government, we've got the Data Use and Access Bill. Yesterday, as I say, it did get passed and it has been agreed. So we now have the Data Use and Access Act. So what was the point and what are the goals of it? So the point of it essentially was that it was generally thought that having to deal with UK GDPR and the Data Protection Act was quite unwieldy for some organisations in terms of from the administration side of things. And it's interesting to know that certainly even from an EU perspective, the Commission are having a look at EU GDPR to see if they can make it a little easier for charities and small businesses within the EU. So there is a bit of a common theme in that it was regarded as quite unwieldy and quite difficult to comply with in some respects. The goals are to make it more pro-innovation, so to not use data protection as a reason for innovation not to happen. As I say, to ease the admin burden. And one thing that's not on the list of things as to what the government intention was, but it certainly is the case in my view, is that certainly one of the reforms in particular paves the way for easier use of AI. And we'll talk about that in relation to automated decision making later. I think it does have a difficult it needs to sort of straddle the interests of being pro-innovation, helping businesses, but also protecting personal data to the extent that it doesn't cause any issues from an EU adequacy point of view, which we'll talk about later. But essentially, as you may well know, currently data can flow freely between the EU and the UK. That's on the basis of an adequacy decision given by the Commission, and obviously one also given by the UK. If we change EU GDPR too much, then there's a possibility that that adequacy decision may be taken away. And since it's up for renewal in December, I think we do need to be quite careful. But hopefully, what's in the Now Act has successfully met its aims of easing the admin burden, but kept the Commission satisfied that we provide appropriate protection for data protection. So when is it likely to be enforced? I think one of the points to note in relation to it, and it is one of the criticisms that has been levied a bit at the new Act, is that there's a lot to be done by statutory instruments. So there's a lot that's been reserved to the Secretary of State in terms of being able to issue regulations via SI. So I think it's not like it's going to be enforced. I don't think it'll be enforced in 2025. I think we're probably looking at 2026 before it's fully in. I think the intention of the government, from what I understand, is that there'll be a phased implementation. So it'll be interesting to see when the first elements of it come into force. So next slide, please. That's the ping pong. That was to explain to you that there has been a bit of to and fro with the House of Commons and the House of Lords. Certainly, the reason it was being held up is that in the House of Lords, they wanted an amendment around AI training and copyright, which the government were arguing it's not really the place for it in this bill. And so could it be dealt with later? So it has ping-ponged, but now we can skip over that because everything's been resolved and we do have an act. So moving on, what are the key changes? There are a number that we need to cover, and I think there's so we're looking at automated decision making, we're looking at cookies, we're looking at reform to the ICO, and we're looking at marketing in particular. So we're going to kick off by having a look at cookies, and Hannah's going to talk you through that.
Thanks, Joanne. So under the current rules, user consent should be obtained before any cookie or similar tracking technology is dropped on a user's device, except where a cookie is strictly necessary. So for a cookie to be strictly necessary, it must be essential to provide the service which has been requested by the user. For example, like for the website to work properly. However, the DUA bill, well, now the Act, amends the current cookie rules under the Privacy and Electronic Communications regulations and introduces new exceptions for certain types of cookies. So if an exception applies, you won't need to obtain consent from a user before dropping those cookies. The exceptions extend to 3 different types of cookies. So the first one is analytics cookies. These are where you collected statistical information about website usage or about how a service is used with a view to making improvements on that website or for that service. The second one is website appearance cookies. So these are where you're optimizing the content of the website or reflecting user preferences about how they want to view the website, such as the font size, or to make sure that the size of the screen that the user's accessing the website on, all the information fits in that screen. And the final one is emergency assistance cookies. So these are where you're geographically tracking a user's device to provide assistance in response to an emergency communication that device has sent out. It is important to note that for any other cookies, such as advertising cookies, social media cookies, things like that, you will still need consent if you're going to drop these. And also, whilst consent's not required where an exception applies, you still have to inform users about the purpose of the cookies you're dropping, and you have to provide users with a clear opportunity to opt out from those cookies if they want to. It's hopeful that the amendments to the cookie rules will allow organisations to more easily collect statistical information to improve websites and services, but also to reduce the cookie consent fatigue by hopefully reducing the frequency of cookie banner pop-ups every time you click on a website. So next slide, please.
So this is one of the key changes, and this is the one I was talking about when I said the amendments to this will pave the way for more use of AI. So automated decision making. Automated decision making has been around for a while. It was governed by the 1998 Data Protection Act and EU GDPR. It was quite heavily restricted by EU GDPR. And what it essentially is that essentially it's a decision that is made by automated means without meaningful human involvement. And where that decision relates to, or it has legal consequences, or it relates to something which has a significant effect on the individual, it was very tightly regulated by Article 22 of EU GDPR, and then subsequently UK GDPR following Brexit. So a lot of people, certainly recently in our experience in terms of when we've been talking to them about how they're using AI, etc., have been wanting to use AI in relation to, say, recruitment. So they've been wanting to filter candidates, or they've been wanting it to review CVs, things like that. It's generally accepted, certainly by it's the view of the ICO, that whether you get a job or not, or whether you go through to the next stage of a recruitment process, is something that has significant effect on individuals. And so it fell within the definition of automated decision making. And it's very difficult to do, because if it did fall within the regulated automated decision making, you could only use it in three main situations. So the first is where you've got explicit consent. The other one is where it's necessary for entering into a contract, and I do emphasise the word necessary. And the third one is where it's authorised by law. So in the recruitment space, it's very difficult, because essentially getting the consent of a candidate is very difficult, explicit consent in particular, because the view is, certainly from the ICO and under GDPR and UK GDPR, is that where you've got an imbalance, then it's very difficult to use consent. And certainly there is an imbalance between a potential employer and a potential employee. So it's difficult to use consent. It's not necessary to enter into a contract with the individual. And also it's not authorised specifically by law. So it's very difficult. So that has been something that has been criticised as technology has moved on. And whilst UK GDPR is technologically neutral, and certainly EU GDPR is as well, there has been a feeling that maybe some sort of technology developments are being held back by some of the provisions of UK GDPR as is, or as was. So moving on to the next slide. Where we've now got to with this is that the position in relation to automated decision making is being relaxed. So the previous rules that I've just been talking about applied to both ordinary personal data, so name, address, education, things like that, and also special category data. So any use of personal data in the circumstances I've just outlined would be restricted, and you would have to jump through the hoops we've just been talking about. The position now is that for ordinary personal data, those restrictions in terms of explicit consent, compliance with law, or necessary for entering into a contract don't apply. There are still safeguards, but those restrictions in terms of your inability to use automated decision making for ordinary personal data won't apply anymore. They will, however, still apply for special category data. So if you're going to use automated decision making, or you're going to use it for filtering, or AI for filtering, for example, and you're going to be looking at things like trade union membership, health, ethnicity, religious beliefs, then those sort of things fall within the definition of special category data, and you will still be restricted in terms of that it can only be used in certain circumstances. And those circumstances are very, very similar to what it was in relation to ordinary personal data. So explicit consent, necessary for the contract, and permitted by law. So it does certainly open things up, because I suspect that a lot of the decisions that people are wanting to use automated decision making for don't relate to special category data. The one thing to bear in mind, it's not a free-for-all. So even though some of the restrictions in terms of the basis on which, in terms of whether you're restricted because of the three rationales behind whether you can use it or not, aren't there for ordinary personal data, there are some controls, as you might expect. There are some safeguards. So if you are planning on using it for ordinary personal data, or any, actually, for that matter, special category data as well, the safeguards are that you need to provide enough information about the decision. You need to allow the individual that's affected to make representations. They need to have the ability to contest the decision, and also they need to have the ability to call for human involvement. So as you can imagine, it is quite a sea change, this. So it does open up the ability to use AI for decision making in more areas than it was permitted before. And if you think about it, the safeguards do make sense in terms of, as anybody will know that has used AI or sort of seen it in action, there may be some sort of strange things that come out of it in terms of a hallucination, or the decision doesn't quite seem right. And so I think the ability to have these safeguards around it does protect the rights of individuals. And I think that's quite important, because one of the things where there has been some criticism of the bill in relation to adequacy is that the Commission may not like the relaxation of automated decision making. So I think that's where we are from an automated decision making point of view. And as I say, hopefully that will pave the way for more use of AI. Moving on to the next slide. I think this is another one that will make it easier for business, in terms of, since one of the reasons and the rationale behind the Data Use and Access Act is to reduce the unnecessary red tape for businesses. I think this will help quite a lot. I think it is quite an important amendment. It will affect both commercial organisations and also public sector organisations, because it looks at the lawful basis of legitimate interest for commercial organisations and public task for public sector organisations. And as you know, in order to be able to process any sort of personal data, you need a lawful basis to do it. From a commercial point of view, certainly legitimate interest is seen as a very flexible lawful basis of processing personal data. It does have its advantages, but it also has its disadvantages. And certainly from a disadvantage point of view is that if you're going to use legitimate interest in the commercial area, then you've got to carry out a legitimate interest assessment. And one of the things you have to carry out is that there has to be a balancing test as to whether or not your use of the personal data is outweighed by the essentially the rights of the individual and the necessary protections of their personal data. And it's not always easy to carry it out. You could get it wrong. The ICO can and does sometimes disagree with people's assessment of the application of legitimate interest. So there is an element, it is quite flexible, but there is an element of uncertainty sometimes in relation to legitimate interests. In relation to public sector with the public task, again, you've got the same sort of issues as to whether or not you're making the right decisions. So where are we going from a reform point of view? On the commercial front, there is a list of examples as to what a recognised legitimate interest will be. So the Act includes the new idea that there are certain legitimate interests that are accepted as being legitimate interests. So you don't have to carry out a legitimate interest assessment in relation to these legitimate interests, because they're regarded as being something that you would expect to fall within legitimate interests. And you can see that there are some examples that are on the slide. So things like direct marketing, intergroup transfer of personal data. And I think that's a really useful one in terms of, because we obviously see a lot of groups wanting to legitimise how the personal data is moved between group companies. And I think that being a recognised legitimate interest is really, really helpful. So that's really good from a commercial point of view. In the similar vein, as I say, there is the public sector side of things in terms of what sits under public task and what can you use the public task lawful basis for. And obviously there are different ones, but again, there's this concept of recognised legitimate interest as to what will be accepted from a public task point of view. And as you might expect, they're more public sector focused. So it's things like public security, national security, prevention and detection of crime. And one that I think is quite useful, certainly from a public sector point of view, who's not involved in sort of law enforcement or security, is safeguarding vulnerable individuals. So in terms of whether these are definitive, or might there be more? As I said at the outset, certainly the Secretary of State has the ability to make statutory instruments and to add to things that are there in the Act. And certainly this is an area where it is made very clear that this list is likely to grow. So I think it's one of these things that sort of certainly watch this space, because I think it is very useful for both commercial businesses and for those in public sector to know that they're on very firm ground with their lawful basis of either legitimate interest or public task. So watch this space, see what happens in terms of what new recognised legitimate interests come out later. I'm now going to pass to Hannah for the next one to have a look at the sort of slightly tricky topic for anyone that's had to deal with them of DSARs and the reform in relation to DSARs.
Fab. Thanks, Joanne. So, as you may be aware, under UK GDPR, individuals have the right to access and receive a copy of their personal data and other supplementary information, which is the kind of stuff that would usually be in your privacy notice. And this is done through submitting a data subject access request, or a DSAR. So many of the rules that surround DSARs are set out in ICO guidance and best practice rather than in actual legislation. So a lot of the time when you might be looking at how to respond to a DSAR, how to carry out a search, how long you've got to respond, all those types of things, you'd be looking to ICO guidance for that rather than actual legislation such as UK GDPR or something like that. However, next slide, please. The DUA bill has actually changed this, and it incorporates and codifies the ICO guidance and best practices into legislation. So it sets out the timing for DSAR responses, such as the time to respond pauses if you need to clarify the request, and that you can extend the time period by up to a further 2 calendar months if the DSAR is complex. It also sets out that individuals are only entitled to such personal data and other information as the organisation that holds their personal data is able to provide based on a reasonable and proportionate search for that personal data. So you don't have to go through everything, find absolutely everything, go through everything with a fine-tooth comb. It's whatever is reasonable and proportionate when you're responding and searching for that data. There's also more information around exemptions and what should be provided to an individual when such exemptions are applied, particularly when it comes to legal professional privilege. We see this one come up quite a lot and get asked for advice on how to apply this exemption. So this is quite helpful for organisations. So if you're going to rely on legal professional privilege as an organisation, you've got to tell the individual the decision to rely on that exemption, the reason why you're relying on that exemption, the right of the individual to make a request to the Commissioner under Section 51 of the Act, the right of the individual to lodge a complaint with the Commissioner, and the right of the individual to apply to a court if they're not happy with your application of that exemption. But this should all be done in a way that doesn't actually undermine the exemption itself. So whilst it's helpful that there's this clarification and further guidance there, it still doesn't fully help organisations when applying that legal professional privilege exemption. The ICO can check and provide further guidance to organisations if required in relation to whether it's appropriate to apply on that exemption, or Joanne and I are always happy to provide advice if that would be useful. The final point is that the bill also introduces a new complaints process, which I will speak about later in the webinar. But essentially, if individuals aren't satisfied with the response that they receive to the DSAR, they should now be coming to your organisation first rather than going directly to the ICO to make that complaint before they can then escalate it.
Which I think will be really helpful, won't it, Anna, in terms of, because we do see a lot of people that their automatic reaction, if they get a response to a DSAR they don't like, is to complain to the ICO. So, but yeah, more on that later, and we'll talk about that later.
So next slide, please.
So this is, again, one of the big changes, and it is focused on charities. And essentially it's around marketing. And you might think, well, what do you mean marketing from a charity's point of view? One of the things that charities have struggled with for a long time is that the ICO considers essentially the promotion of their aims and contacting supporters and seeking donations as being direct marketing. And they're subject to the same direct marketing rules, but with a smaller, well, quite a big exception, as commercial businesses. So charities have lobbied for this exemption, or this ability to use what's essentially an opt-out approach to direct marketing for a long time. Marketing's certainly tricky, and we do get a lot of queries in relation to marketing, because essentially you need to be able to show for any direct marketing, whether you're a commercial business or whether you're a charity, that you have a lawful basis to market. And certainly, one of them is consent. But consent is quite difficult because you essentially have to meet the GDPR level of consent, which requires it to be granular and specific and freely given, etc. And also, quite a lot of people don't like giving consent and won't tick your box. So it is quite tricky from that point of view. And the other one is potentially the soft opt-in. Now, the soft opt-in is from an electronic point of view, and I am talking about electronic marketing in this section for charities. One of the things that makes electronic marketing, so email, SMS, quite difficult is that in addition to UK GDPR, you've got the Privacy and Electronic Communications regs that sit on top of it, and they add an extra layer of compliance on top of UK GDPR, where you're talking about email. And most people will market via email these days. Most people won't use snail mail unless they really, really have to. So one of the options, if you're using electronic marketing, is, in addition to consent, and the general rule is you should have consent, is that there is an exemption which is called the soft opt-in. And the position in relation to that is that if certain criteria are met, you go for the opt-out rather than the opt-in approach, and therefore generally the engagement is better because most people they just don't tend to opt out unless they're fed up with the marketing, in terms of if they're getting it too often or they're not interested in it. So it does have more engagement than if you ask people to provide GDPR level consent. So when can it be used? So essentially for a commercial business, it can be used where you've either sold something to the individual or you've been in negotiations for selling goods and services to the individual. You have got to be wanting to market something which is the same or similar. You've got to have given an opt-out in terms of the ability to not receive the marketing at the point at which you collect the personal data, and you have to provide an unsubscribe or an ability to opt out in every subsequent communication. So, the unsubscribe in emails, that's why a lot of them are there to comply with PECA. So that's fine, and hopefully anybody that from a commercial side of things that has got any questions in relation to the use of the soft opt-in, that's sort of laid out the ground rules for when you can use it. That's not been available to charities. It's expressly not been available. They've previously had to use consent, which obviously is quite tricky. We can move to the next slide. So now, under the new Act, the soft opt-in approach will be available to charities. It is expressly stated to be for charities, and it is in relation to email marketing. So not at the moment, we don't think from the wording that it relates to SMS or the like. And essentially, you can use the opt-out approach I was just talking about if essentially the charity is wanting to communicate with people for furthering its charitable purposes or aims, or seeking donations, for example. In a similar sort of way to where you've got a commercial business, it's not like a cold calling thing. It's got to be to somebody who they've had some engagement with. So somebody that has either offered support or previously engaged with a charity in relation to making a donation or providing support to that. Also, like the commercial side of things, there has to be an opt-out at the point of the collection of the data, and also there has to be unsubscribes for each communication that goes out to the individuals. If you can meet those requirements, then, as I say, rather than using consent, a charity can use the soft opt-in. And I know we certainly have some charities that are registered with us. I think one point that I would make in relation to it, and I think it will be the same for charities, but it's certainly the case for commercial organisations, is that you can't backdate it, would be my understanding of it. So certainly from a commercial point of view, if you have been using consent previously and then you want to move to soft opt-in, you use the soft opt-in in relation to new customers. You don't try and migrate your consent-based customers to the soft opt-in. And the reason for that is the ICO basically says that if you have nailed your colours to the mast in relation to a lawful basis for the use of personal data, you can't change your mind. You pick it and you're stuck with it. I suspect that will be the same. So I think it will be of use for charities, but I suspect the same approach will apply as for commercial businesses, and it will only be going forward, so that the database that's already in place on a consent-based will have to be used on the consent-based, and it will be new people they engage with that will be on the basis of the soft opt-in. But hopefully it will be of assistance to charities, and I think the level playing field is to be welcomed, because I think it has been very difficult to understand why commercial organisations get the benefit of the opt-out approach and charities haven't to date. So now I'm going to pass back to Hannah to look at complaints.
Thanks, Joanne. So as we've already mentioned, there is a new complaints procedure to come in. Under UK GDPR, there is no requirement for an organisation to have a formal complaints procedure in place when it comes to data protection complaints. But under the new Act, you will need to have one. So complaints should be first submitted to an organisation before a complaint is submitted to the ICO. So this means that organisations will be required to have a complaints procedure in place for individuals to use and for the organisation to follow. And they'll also need a way of being contacted should an individual want to raise a complaint with them. So this could be like an electronic complaints form or something like that. And as part of the complaints procedure, organisations will have to acknowledge a complaint within 30 days and take appropriate steps to respond to it. You can't just sit around and not do anything for a while. And then also under the Act, the Secretary of State may issue regulations requiring an organisation to notify the ICO of the number of complaints made, but this isn't the case at the moment. That's something that, like Joanne said, would have to be made through a statutory instrument during the next few months before it comes into force. And that's complaints in a nutshell. So moving on to the next slide, which is purpose limitation. So one of the core principles of UK GDPR requires personal data to be collected for specified, explicit and legitimate purposes, and you can't further process that data in incompatible ways with that purpose. So this prevents data from being misused for purposes outside of the scope for which it was collected. So under the Act, the new Act that's coming in, the general principle remains the same, but what it does do is provide guidance to work out where the line is drawn when it comes to incompatible purposes. So when determining whether a purpose should be considered incompatible, you would need to have a look as to whether there's a link between the new and original purpose, what the context is in relation to when the personal data was originally collected, what the nature of the processing is, particularly whether It involves special category data or criminal convictions data, what the possible consequences are for individuals, if the further processing being contemplated actually goes ahead, and what safeguards will be in place to protect that personal data, such as encryption or pseudonymization or something like that. And we think that it'll provide greater clarity as to how data can be used when it comes to purpose limitation and things like that. So moving on to the next slide, which is about new special category personal data. So as you may be aware, Article 9 of UK GDPR sets out different types of special category personal data. So this is personal data which is seen as particularly sensitive, and therefore it requires greater protection than just your ordinary personal data like name, address, contact details, things like that. So special category personal data includes data relating to racial or ethnic origin, political opinions, religious beliefs, health data, and things like that. And then Article 10 is the one that deals with criminal offence and criminal convictions data. So under the bill, the Secretary of State has the ability to add new types or categories of special category data. Currently, the Article 9 list is exhaustive, so you can't add anything else to it. It is important to note that whilst the Secretary of State can add categories and remove the categories that they've added, they don't have the power to remove the categories of special category personal data that are set out in Article 9 that we all know at this moment in time. And the idea behind bringing this provision in is to be able to address technological developments as they arise to ensure personal data can be appropriately protected. Just to kind of, make sure that everything's protected, and if anything else is seen as particularly sensitive, it can be safeguarded. So we're now going to have a look at children's personal data, and I will pass back to Joanne.
Anybody, and I know we've got a number of schools and colleges that are registered today, anyone that deals with children's personal data on a day-to-day basis will know the general approach of the ICO is that the personal data of children needs to be handled with kid gloves. It isn't codified at the moment, but it is in guidance, and certainly the approach is that because children don't necessarily understand what they're consenting to, or the need to minimise the personal data they make available, is that controllers who are processing children's personal data need to have an eye on the fact that children are less experienced and do need an extra layer of protection. It's being codified under the new Act in relation to a particular type of use of children's personal data, and that's in relation to what are called information society services. So that what that is, it's essentially online stuff. So an online shop, streaming, apps, social media. So in that context, essentially, it has to be recognised when the controller is looking at data protection by default and by design, that a higher level of protection has to be given to children's personal data. And if you think about it in terms of the sorts of things that we're talking about, they're the sort of things where children may well easily be exposed in terms of providing too much data, etc. So it entirely makes sense in terms of the list where it's come from. I think where we are is that it's helpful that that's codified, but that obviously doesn't take away the general position in relation to children's data. And so if you handle it outside the scope of apps and social media, etc., then it still has to be handled with kid gloves. But it is an interesting, I think it shows the direction of travel, that there are things that are being codified under this legislation and put into law that were previously just in guidance. And certainly I think it's helpful in relation to children's data that that's happened here. So next slide, please. I'm not going to spend a lot of time talking about this. It is quite specific in terms of research data. what falls within research data and how it can be used is quite important, because there are a number of exemptions in UK GDPR that relate to research data. So, for example, the right to be forgotten, there is a carve out in relation to some research data. So it does have an importance in terms of, if you're in that field, as to the fact that if it's a broader definition of research data, then you've got a broader category of things which are within the exemptions. There's been some discussion as to what the scope of research data has meant for a while, and whether or not commercial research data could fall within the definition of it. This has now been put to bed in the Data Use and Access Act, and it's been confirmed that commercial research can be research within the definition and can get the benefit of the exemptions. I think one of the things that's also relevant if you're in research is that the scope of the consents that are given to research are sometimes quite narrow. I think sometimes it causes problems should the research find something which is sort of new and innovative, in that the consent hasn't mentioned it because it was new and innovative, and it's all a bit sort of chicken and egg, and therefore the consent doesn't apply to the new and innovative side of things. So the other thing that has been included here for anyone that is involved in research is there can be a broad general consent to the use of personal data for research, including research or outcomes that are currently unknown. So that does make life a little bit easier if you're in the research area. As I say, not planning on spending a lot of time on it. I'm going to hand quickly back to Hannah, who's going to have a look at fines.
Yeah, thanks, Joanne. So this is an interesting and important point to note. So under the Data Use and Access Act, the ICO will have enhanced powers to enforce PECA. So as part of these enhanced powers, it can apply maximum fines of £17.5 million or 4% of the annual turnover of the organisation or the group that the organisation belongs to, if applicable, whichever is higher, for breaches of the PECA rules, which include breaches in relation to cookies and direct marketing. So this means that this change means that the fines for breaches of PECA will align with the maximum fines for breaches under UK GDPR. And importantly, it's a significant increase from the current maximum, which is £500,000. So it's therefore important for organisations to be mindful of this, particularly when you're making decisions around cookies and direct marketing, and possibly also it would be good to go back and have a look at past decisions you've made, especially when it comes to marketing and things like that, because the scope of the ICO's powers don't just stop at this moment in time. They could look at retrospective breaches also.
Yeah, and I think this is particularly important because they are very active in PECA, aren't they? PECA enforcement. I think if you spend a lot of time on the ICO website, which probably spend more time than I should on the ICO website, and looking at the fines, a lot of them are for PECA breaches. Because it's so rigid as to the requirements for PECA. It's easy for the ICO to bring fines, and I think it's a bit more nuanced when you bring in fines under UK GDPR. So it is very important, I think, this change.
Next slide, please. So just quickly having a look at this one. For reasons unknown, the ICO will be abolished and the Information Commission will be set up instead. This change mainly seems to be around restructuring the Information Commission, so it includes a board, a chair and a chief executive to bring it in line with other UK regulatory bodies. But all powers of the ICO will be transferred to the Information Commission, and it will essentially do the same thing from what the legislation reads as. The role will be expanded slightly so that it can deal with emerging technology, and it'll also have the ability to introduce updated fees for organisations so it can increase the funding that it gets. But that's that in a nutshell. So I'll pass back to Joanne to talk about adequacy, which is a big topic at the moment.
Yeah, so I think as I mentioned earlier, sort of flagged this earlier, I think the Act has to walk a fine line between reducing administrative burden for organisations and keeping the Commission happy. It's important to keep the Commission happy because, as I said, currently the position, the adequacy decision from Europe is under review. It was due to expire in June, but there's an extension until December. But obviously, they are watching and waiting. And one of the reasons for the extension was they wanted to see what was happening in relation to the new legislation. For anybody that carries out data export to a country that doesn't have adequacy, you will appreciate how difficult it is to do that. So it is very important that we preserve adequacy. Hopefully, it will be fine, and the Commission will be happy. But I do think that is one thing to watch for in terms of what is the Commission saying about the new law and what will that mean for EU UK data export going forward. But I think that's a watch this space sort of thing, rather than any definitive advice at the moment. So moving on to the next slide. Just to wrap up, I'm just going to have a look at some things in terms of, well, what should you do now? Obviously, we've told you all the things that have happened in terms of the main changes that are in the Data Use and Access Act. Sorry, I need to get used to calling it an act. But what should you do? So one thing you should certainly do, and I would always recommend this to any business, is data mapping. You need to understand what personal data you've got and how you are using it. If you don't know that, then data protection compliance becomes very difficult generally. And certainly in terms of thinking about how these changes may affect your personal data and how you use it, if you don't know this, then you're not going to be able to think about what you might need to do to either take advantage of some of the relaxations in the reforms or some of the tightening up that has been included. So definitely, I'd say understand your data. As part of that, I'd also say you need to know what of your personal data is special category data and what special provisions or policies or procedures or controls do you have in relation to special category data? Because if the categories are expanded as they are going to be, as Hannah was talking about, then obviously you need to know which of your policies and procedures you need to extend and whether or not you need to do anything in terms of picking up any new ones. The next one is cookie compliance. You need to understand what cookies you're dropping. I'd always say you need to understand what cookies you're dropping anyway. Don't just leave it to the tech people. You need to make sure that you know, because certainly we do see cookie disputes, and understanding what's being dropped and on what basis is quite important to know whether or not you're at risk of a cookie dispute. But also, in terms of if you understand your cookies, you'll know which ones you now don't have to ask for cookie consent. So the cookie consent banner, where people are opting out, you've got more now that will be ones where you know it doesn't matter whether they consent, you can just drop them anyway. Complaint handling. As Hannah said, there are new rules around complaints in terms of having to have an appropriate procedure, and the fact that the ICO are going to expect you to do a lot of the heavy lifting from a complaints point of view before it gets to the ICO, which does have an advantage because obviously, you know, people running to the ICO with a complaint which may be a pretty minor issue is quite unhelpful, but certainly having the right complaints procedure and having the mechanisms and watching the timing as well, because as Hannah said, you've got 30 days to look at and deal with a complaint. Automated decision making. I think, as I said earlier, the changes in relation to automated decision making do open up the use of personal data from an AI point of view more. So if you've been thinking about it, then I think, you know, it's a good time to think, well, when might I use automated decision making? Certainly, I'd say in relation to ordinary personal data. Obviously, as I said earlier, the controls around special category data are still really quite strict, but it does open things up. And so, you know, you might want to take a step back and think about how may you take advantage of some AI decision making in relation to aspects of your business. Privacy notices. Always say about privacy notices, if there's any change in what you're doing from a data protection point of view, then you need to make sure it's properly reflected in your privacy notice. Quite often that gets overlooked. So the changes are implemented, but it's not made transparent in your privacy notice. And certainly it's important to make sure that that's right. Direct marketing. I think if you are a commercial business, it's worth making sure, looking at your direct marketing. If you're using consent, might you be able to use soft opt-in? If you're using soft opt-in, are you jumping through the right hoops to be able to use soft opt-in? But certainly from a charity point of view, I think this is a big change for you in terms of the ability to use soft opt-in for your aims, ideals, fundraising, etc. I have said that I don't think it can be backdated, and I've put that also on the slide. And finally, before we get to questions, a do not forget slide, which is the next slide. I think there are there are quite a lot of changes that have been made in the Data Use and Access Bill, but the core principles that are in UK GDPR haven't changed. So in terms of making sure that, any processing is lawful, fair, transparent, you meet data minimization rules, you ensure the data is accurate, you only store it for as long as you need, all of that is still there. So, these are changes that don't get rid of UK GDPR, don't get rid of the Data Protection Act. All the core stuff is there, they're just varying certain aspects of it. So that's the end of what we've got to say formally. Josh has appeared with questions that I think people have been putting in the Q&A.
Yes, we've had some questions in. Thank you very much for those. Just to go over the requirements for ADM again, is consent needed, or are there other alternatives?
For automated decision making. So if you are looking at ordinary personal data, then you don't need consent for it. The rules have been relaxed. So the hoops that I was saying that you had to jump through in Article 22 for ordinary personal data about consent, compliance with law, necessary for the contract, they've gone. In relation to special category data, then the controls are still there. So you do still need to jump through hoops in relation to those.
Okay. Another question came in about the fine increase for PECA and the interplay with that, and is the same breach under PECA going to result in the same fine under DUA?
Is the question around whether you'll get fined twice?
Correct.
Yeah, I think so.
Once, I suspect. Certainly in our experience, and we have dealt with a number of fines for clients, not clients that we advised in relation to their compliance before they got fined. Normally, when there is a PECA breach, they roll in GDPR, but they don't fine twice in relation to it. So I can't categorically say what the ICO will do, but current practice is you get one fine rather than suddenly getting hammered by, 2 million quid fines.
Yeah, to cover everything.
And an administrative question here is just, will a copy of the slides and a recording of the session be made available afterwards?
Yes, it will. Anybody that's registered, so even if you've got colleagues that haven't been able to attend, they will get a copy of the recording, and the slides will be part of the recording. Great. Well, I think unless anybody has any new questions, I think in terms of, we've got a question about when to start making the changes. I think in terms of planning, obviously it's not yet in, it's very, very new in terms of hot off the press. I think planning should definitely start now, and then as things are coming in, you can adjust your practices, but definitely planning should start now. Got any others?
I think someone asked when DUA will come into force. The short answer to that is we don't know at the moment. As Joanne said, we think it'll be in about a year's time, in about the next 12 months, but it's the bill's still waiting to have royal assent to pass into an act officially. So hopefully after that happens, we'll have some further indication as to when it will come into effect.
Yeah, and I think the intention, as I understand it, is that it'll have phased implementation as well. So a bit like the EU AI Act, bits of it will come in before other bits of it. So it's probably worth watching this space as to which bits will come in for you. We've also had somebody from a charity ask when the soft opt-in becomes available. Again, it will be when that part of the Act comes into force. So unfortunately, it's not as of today. We got any others? Oh, an interesting question in relation to contracts as to whether or not you should reference the Data Use and Access Bill in contracts, presumably in relation to the definition of data protection laws or UK data protection laws. I guess if you wanted to be ready, you could say the Data Use and Access Act as from the point at which it comes into force. But at the moment, as I say, it's not currently law. But if you did want to, you as I say, thinking about it, you could get ahead of the game in your definition. I don't think there's. Hold on. Oh, DPOs. Somebody's asked a question in relation to DPOs, and I suspect that has come out of the previous reform. So, as I said, there are two other previous reforms. This is sort of third time lucky under the Conservative government, and there was a proposal to essentially abolish DPOs. That's gone. That's not in this. So your position is as before in relation to the appointment of DPOs and when you need to appoint and who you should appoint.
I think.
Oh, yeah. So I think we've had a question in relation to Information Society Service. Essentially, it's a tech service. So it's things like apps and streaming, social media, online games, things like that. It's a tech service rather than a general service. Yeah, it's to whether or not we'll be warned. I think that there will definitely be a lot more clarity around when the various provisions will come into force, because somebody's asked whether we'll be ambushed. It won't be like the sort of surprise that dropped yesterday. It does tend to happen actually when I'm doing a presentation in terms of things change the day before and frantically have to sort of change the presentation. But yeah, there will be notice. There definitely will be notice in relation to what's coming in and when, to give you the time to prepare yourself, because otherwise it would be unfair for the ICO to suddenly start enforcing tomorrow, and you're not having prepped it. Yeah, I think we've been asked again about the soft opt-in again. That you'll be told when that's going to come into force and when you can take advantage of that. So it's not as of today. I think that's probably everything. So the only thing I'd say is thank you very much for coming. If you could fill in the feedback form, that would be great. And one of the questions on the feedback form is because we've had a lot of questions about whether or not we'll be doing something from a marketing point of view, is we're planning on doing a webinar that focuses entirely on marketing, both from a commercial and also from a charities point of view. So if you're interested in that, please tick the box and leave us your details. But other than that, thank you very much.
Thank you.
And have a good day.